Okay, Chris.
Gentlemen.
How you doing?
Pretty good.
Okay.
Yeah. This you're going to have to chair for because I'm on board of directors. So.
That's all right.
I knew it.
Still in the same
Just
list.
letting everybody know we are live and recording.
Okay. Great. Okay, it's 6:31 right now. We'll just wait another 3 or 4 minutes to see if our 5th board member shows up.
That happens more and more. People are just tired.
Holly, do you have a phone number for Lisa Matondi? Oh, there she is. It's always the kids who live closest to school. Okay, it is 6:33 on August the 6th, 2025, and I'm calling this meeting of the Brookfield Planning Board to order. It's being recorded, both in audio only, and also the town's contractor is video streaming it and recording it. So for the purposes of the audio recording, I'd like to have each of the members of the board state their name.
Steve Carmen.
Chris Gorman. Bruce Clark.
Lisa Matondi.
And Kevin Erkola. Okay, very good. You have the agenda before you tonight. I'd like to start with the minutes of May 7, 2025. These were the corrected and expanded minutes in deference to a number of complaints received from people that they weren't detailed enough. So I hope these will be better. Just to make sure that we have all the bases covered, I will entertain a motion to rescind the board's previous acceptance of the minutes of the meeting of May 7, 2025.
So moved.
Is there a second?
I'll second.
Okay. All in favor of rescinding the board's acceptance of the May 7, 2025 minutes, please signify by saying your name and I.
Steve, I.
Chris, I. Bruce, I.
Lisa, I.
And Kevin, I. And Bruce, actually, you that's something that you can't vote on, but everybody else can. Okay.
No, there's a question I voted on something another time that,
Yeah, yeah. But just to let you know, you can save your breath.
Point of order, Mr. Chairman. Why, what's going on with Bruce? Why can't he vote on it?
Mr. Clark is an associate member. He only votes on matters relative to special permits.
Okay. I got another question. When have you discussed these, are you going to discuss those meetings tonight, the complaints?
I'm sorry,
When are you going to discuss when is the board going to discuss that you have to do?
I'm not sure. Do you have a copy of the agenda? What we're going to discuss is on the agenda. Do you have one?
open meeting law complaints, it'd be towards the end of the meeting.
Yeah?
Oh, at the end, okay.
Yep.
We were discussing it now, that's why I asked. Okay.
No.
Thanks.
And actually, the complaints I was referring to were not open meeting law complaints, but there you are. Okay, so has everybody had a chance to review the minutes that I expanded?
Yes.
Any corrections or additions to those? It's up to, I believe, 7 pages now, including the sign-in sheet. No?
Nope.
Nope.
Okay, well, in that case, I'll entertain a motion to accept the corrected minutes of the planning board meeting of May 7, 2025.
I'll make a motion to accept the expanded minutes for May 7th, 2025, as drafted.
Okay, is there a second?
Second.
Okay, all in favor, signify by saying your name and aye.
Steve, I.
Chris, aye.
Lisa, I.
And Kevin, aye. All right. Very good.
Chair, can I just make a comment?
Yes,
I hope the audience here reads the open meeting law guideline booklet, because it does open your eyes to what must be said. And a lot of it doesn't have to be said. It's the gist of the meeting, it's not verbatim. But if you read the guidelines, maybe you'll understand it better.
that allows for a lot of or some latitude anyway, in interpretation, but moving on. So the next item on the agenda is the old business, the Sun Fusion special permit. I made copies of a draft that I put together at the board's suggestion last meeting, and at the July 2nd meeting anyway. And just wonder if you'd like to go through those point by point, or if there are specific things that you would like to talk about.
Oh, another copy.
Yeah, sure.
Thanks so much.
There's the record of proceedings on the application, which is just a history of the various sessions of the public hearings, and then finally what the ultimate decision of the board was, which is still up in the air at this point. And the findings of fact, again, talking about these A through M. Some of which have to be included according to the zoning law, the zoning act, and our own zoning bylaw. I think under the findings of fact, letter E, It talks about the property being situated on Assessor's Maps 4B, Parcel 14, located in the rural residential district. And it says that an extraction facility defined by reference to CMR 935 500.000 as manufacturing is not an allowed use in a rural residential district, according to the use regulation table. The applicant seeks relief under Brookfield zoning bylaw section HE 14 waiver, and under use regulation table section 7A, any use which meets the intent and purpose of the zoning district in which the permit is sought. So one of the things, in order to even have a question of whether or not to approve the permit overall, we have to take a vote as to whether we want to waive the prohibition on manufacturing. And so,
I have given my opinion on it. I still feel versus another application coming forward for a different parcel of property, this property, as submitted, I don't believe it have an ounce of detrimental effect any further. I don't mean detrimental. I don't think the effects are going to be any different whether this manufacturing process was inside the building proposed as to what we could approve under the cultivation. I think we could have far worse effects under a permitted use application.
Yeah, because it would be broader.
It would be broader. It could be, you could have neighbors much closer. So and once we approve or disapprove the use for this facility, that facility can't come back to us again for a secondary use in the same building. Am I correct? For a reconsideration.
They could come back if they wish to amend their special permit in some way, but, you know, if we turn them down once, the chances are that unless something else significant happens, we'll probably turn them down again, so it would be a waste of
Yeah, I'm just looking at it as, there are other places in town this facility could have been proposed with manufacturing.
Yep.
And I think they're far more detrimental than this particular piece of property.
Maybe. Yeah. And I happen to know, and I checked with town council to say that I can share this with the board, that the applicant has made the statement to me that he is planning to do the manufacturing elsewhere at this point. He's made other plans for that. So I don't have that in writing, but that's it.
Elsewhere could be in this town, though.
It could be elsewhere in the town, yeah.
That's all I'm getting at.
I don't know the location.
Yeah, and if it's in an area of town that's allowed. Kevin, point of order on this.
Yeah.
Do we have to seat Bruce?
No, I can declare that, well, you know, we have 1, 2, 3, 4 regular members, and Bruce, an associate, automatically sits in when we're discussing special permit, or if a member of the board is missing. Yeah.
I just didn't know if we had to seat him now that it's part of this. Because this is now different. And I just had a question about, did Steve recuse himself? I don't know how that's.
All right, so that's a good question. Can we set that to one side for just?
Sorry. Those are two things that I know are kind of like
Right.
about the same thing.
All right.
Because then we would unseat him
Right.
if we did that.
So I, as chair, can just make the statement that Mr. Clark is
Yes.
fulfilling his job as associate member of the board in this regard. And nobody has any problem with that? Nope. Okay, all right, all right. All right, so when we get to the end of that, well, maybe I'll take care of it now. Because we are lacking one board member because of the death of Mr. King, I checked with town council, just things were getting too complicated, and they said I was within my rights to have Steve deliberate with us
Yep.
and vote on this permit, because he is an elected member of this board. So,
And for the record, I did not recuse myself. During that first meeting, there was a surplus of members in a sense. If Bruce was to sit in as an associate member, well, with the death of Jeff King since then, the circumstances have changed. So now we can have a 5-member board if I partake.
yeah, right.
Without my participation, we would not have a full board, so there's a seat that's vacant. But for all intents and purposes, I am qualified to deliberate on this project.
Yeah, there are also questions about board members making up a meeting that they may have missed by reviewing the video and or the transcript, and that is part of what's called the Mullen Rule, which is part of Massachusetts general law that allows a board member of a board like this to do exactly that for one meeting only, maximum. And this town accepted that part of Massachusetts general law at a special town meeting in the fall of 2006. So it's on the books here. And the fact that you weren't a member on April 9th, but you were here at the meeting, so I know you were here and you knew what was going on. So that's not. And of course, Lisa reviewed the video of the meeting that she missed. So, and the fact that I also asked them the fact that Mr. Clark was not sworn in yet on May 7th, if that made any difference. No, because he'd already been appointed by the select board. So having him sworn in at that point was not, in the view of town council, a relevant issue. Plus, it was the only meeting anyway that there was any issue for, so and you were here, so nobody actually missed anything
I
overall.
appreciate it. I just wanted to ask those questions.
No, good.
Thank you.
Yeah, so that's okay, so back to this. So we need to decide whether or not to waive the prohibition on manufacturing for this facility. So I'll entertain a motion on that issue, either to waive or to, cleaner to say motion to waive, and then if it fails, there's no waiver. Everybody understand that?
To waive the manufacturing?
Yeah, to waive the prohibition
Okay.
on manufacturing. Okay. All right, so does anybody want to make that motion?
I will motion to waive the manufacturing, prohibition of manufacturing.
Okay, is there a second?
I'll second.
Okay. It's been moved and seconded to waive the prohibition on manufacturing in a rural residential district. All those in favor of the waiver, please signify by saying your name and aye.
Kevin, before that, can you open the topic to discussion?
Oh, I'm sorry, Steve. Yes, of course. We talked about it before, but please, well, yeah.
Okay. As far as I'm concerned, the classification of manufacturing, as is written in our land use regulations, the name of that particular item is marijuana product manufacturers, and there's a state license with that same exact name. So if state licensure is required for that particular activity, and it's not permitted per our land use regulations in rural residential, I don't necessarily see why there would be a reason to waive that, and I don't think the planning board has the authority to waive land use regulations.
This is under section 8G14 waiver, which specifically states that we do have the right to waive any section of
This
the-
section?
Of the, yeah, or any section, actually. Now,
No.
let me read it to you.
Okay, please.
Not that I'm recommending that we do anything in particular like that, but, let's see. Okay, 8G14, waiver. The planning board may, in its discretion, waive or modify any of the requirements set forth in this section, that would be section 8G, if the board determines that such a waiver does not derogate from the purpose of this bylaw and is in the public interest.
This section.
Yeah,
What is this section?
this section, section 8G, which is titled Medical/Adult Use Marijuana Facilities.
Okay, so that's section 8, right?
Right,
And
8G.
8G. And where are the land use regulations defined in our zoning bylaws? In section 8G or section 4?
Both.
Is it defined in section 8G? The land use regulation table is in section 4, which makes the classification of marijuana product manufacturers not being permitted in rural residential.
Right.
It makes no mention of that in section 8G.
Let's see.
I mean, this might just be a technicality, but I think based on the way that the zoning bylaw is written, that waiver does not apply.
I think you may be right. I'm not finding it either. Okay, well, if we don't waive it under use regulation table, section 7A, the effect would be the same. If we were to deny a waiver under that.
Well, I'm pretty sure Steve's a no and I'm a no, so I think it's a moot point.
So, well, all right, so in that case, if we vote not to waive the prohibition of manufacturing under the use regulation table, section 7A, then I will delete the portion in this draft that refers to HG14.
That sounds fair.
Okay, all right. All right, okay, so what was Holly, do you have our motion, the exact words of the motion? You didn't write it down, did you?
Which motion?
The motion on waiver of manufacturing?
For the prohibition.
Prohibition on manufacturing.
Prohibition.
Yeah.
You did. What's the exact wording?
Motion to waive the prohibition on manufacturing.
Okay, so shall we, in that motion, shall we specify that the prohibition is in the use regulation table, or shall we just say that in the Brookfield zoning bylaw? How specific do we want to get?
I think we should just vote on it and then it's,
Okay, well, we have to be specific so we know exactly what we're voting on here, and it stands up to legal scrutiny.
I think we're not voting on the bylaw per se, we're voting on, I think, what I think we're voting on is if,
Whether or
is the
not,
actual, we're gonna approve it or not. So it's not really, it doesn't matter which bylaw it is, I think it's more, which bylaw he's trying to use, I think it's more, we're voting on the actual, if we're approving it.
right, we're just doing that for reference so that people reading this document will know where the waiver is, what the waiver is based on in the zoning bylaw.
Yeah, why it's not allowed.
Right, exactly. Yeah,
So it's not allowed because under this section, it's not allowed.
okay. So the waiver then that we're referring to is the one in the use regulation table.
Taken off.
Yeah. And that would be the
Still Chinatown.
waiver that says any use which meets the intent and purpose of the zoning district in which the permit is sought. And I, for one, do not see that manufacturing, based on what we've already had the town approve with regard to manufacturing in general and with marijuana manufacturing in particular, is anything that would meet the intent and purpose of this particular zoning district. So that's my take on it. Okay. Any other?
So how do you want to move with the motion that's
Well,
in front of you?
if nobody else has anything to add at this point, we're going to take a vote. So it's time to take an action. All right.
But with the comments that were made, there is no allowed use under a waiver.
I had for some reason I had thought there was one in 8G for this, but it wasn't included in that. But the waiver function is in the use regulation table, rather, which is a broader type of wavering, and it would apply to any type of manufacturing. So,
I think we just take a vote just to make it easy,
okay,
so we don't have an issue.
all right. You all ready? Okay, so the motion is to approve a waiver of the prohibition of marijuana manufacturing in a rural residential district. All those in favor of approving the waiver of that prohibition, please signify by saying your name and aye.
Bruce, aye.
Lisa, aye.
All those opposed, same sign.
Chris, no?
Kevin, no.
Steve abstain.
Abstain, okay. All right, so there's not a majority in favor of waiving the prohibition, therefore the manufacturing use is prohibited. And then under F, in that same section under findings of fact, the applicant proposed more than one principal use for the property. And I've already written, the planning board did not grant a waiver to allow manufacturing on the property, so eliminating the second use for which a waiver was sought. So that's moot.
Yep.
And then under G, the applicant has applied for the required licensing through the Massachusetts Cannabis Control Commission, but has not received a provisional license as required for grant of a special permit by the zoning bylaw, section 8G 13B. The applicant seeks relief from this condition under section 8G 14 waiver. The applicant has submitted copies to the planning board of all materials required by the CCC in application for said licensure. At the planning board meeting of August 6, 2025, a motion by somebody, second by somebody, to waive the submission of a provisional license as a requirement for grant of the special permit for this project, and then we decide that. So in order to grant the special permit, section 8G 13B says, and this is one of the requirements, 15B. The facility has received a provisional certificate of registration or provisional license from the CCC, and it's in compliance with all applicable state laws and regulations. Okay. As that license, no provisional license or final license for that matter has been yet issued by the CCC for this applicant, we would need to waive that requirement of the section on adult medical use marijuana. Is there a motion to do so? That way, a motion to waive the requirement of having a provisional license submitted prior to issuance of the special permit.
I'll make that motion
All right.
to waive the license requirement.
Is there a second?
I'll second.
Okay. All right, discussion. All right. So,
Yeah, I feel like it's kind of like a carrot before the goat. Neither one's moving until one approves, kind of. You know what I mean? It seems like no matter what, he's going to be held up. I think it does no harm for us to give him the special permit, so he at least has that insured, ready to go when the state finally approves on their end.
yeah, that was my feeling also. Legally, this board or any board cannot condition their actions upon the actions of another board. So we can say that the applicant needs to have these licenses. In fact, under the Massachusetts cannabis control regulations, he needs to have a license in order to go into business. But we can't say that, that license has to be granted and submitted to us before we can take action on his application for a special permit. That's just the way it is. And if you know how glacially slow the wheels of government often move, it's not surprising. So that's my feeling on that. Anybody else have any other?
Well, I think we went through this whole proceedings knowing full well he didn't have a license.
Yeah, and I checked the calendar for the Cannabis Control Commission regularly, and they were always backed up. So it's not surprising.
So what do you think the purpose in our zoning bylaws is to have this as a finding, and do we think it's otherwise satisfied?
I think that at the time that bylaw was written, the expectation was that the wheels of government would move more slowly, more swiftly, and not being borne out by the facts. So,
I would assume it's the same understanding. You can't open up a shop without the license. So you can't really file for, in theory, if you're, you can't open up an electrical shop before you, well, you can't even have a building for an electrical shop until you have the license. But, this is a little different. This is one of the weird industries that kind of, takes years. You're approved, but you're never approved. So I think the intent was for, to make sure you have it or you're going to do it, or it's,
Right.
but it's delayed when it goes against the government's wheels, like you said.
yeah, and I don't know if we've gotten to that part of the draft, but I have written into the conditions that before he actually starts operations, he has to present a copy of the final license to this board, to the zoning enforcement officer, and other town entities.
Okay.
Yeah, all right. Other comments? If not, are we ready to vote? All those in favor of waiving the requirement to receive a provisional license from the applicant before granting a special permit for their use, please signify by saying your name and aye.
Chris, aye.
Bruce, aye.
Lisa, aye.
Kevin, aye. Sid?
Steve abstain.
Okay. All right. All right, so the vote is not unanimous, but that's, okay, it's a majority vote anyway. All right. All right, then. I think. Yes. Okay, and then the site plan review is required as part of the permit process because of the scale of the proposed use, meets threshold requirements for site plan review. This is in section K of that same setting. And we did have stamped drawings of the site plan, which is what we have our consulting engineer review. And he reviewed everything. That included the drawings for the wastewater septic system as well. Yeah. We don't have drawings of the interior of the buildings other than sketches, but that's really the domain of the building inspector, and we don't have anything to do with that part. And then site plan review requirements, section L. If anybody has any comments about any parts of that.
I have one item.
Okay.
It's on page 5, 13C8A7, minimize lighting intrusion onto public ways and abutting properties. Could we add something about the shielding of the security lighting? This description here, I think, covers the screening of lighting from interior. But I believe that the application does cover some details about screening the lighting, the security lighting on the exterior.
So it says motion-activated downlighting will be used in both the parking area and as required for security.
Yeah, he had 3 lights on the side, I believe.
Motion-activated downlighting will be used, okay.
All right.
In both the parking area and as required for security. Okay, yeah, that's good.
All right. Okay, all right. So then moving on to item M, which are the special permit conditions listed in section 13C10, A through G, in the zoning bylaw. These are findings that have to be true in order for the granting of a special permit. Are there any of those that anyone would like to amend or otherwise dispute?
The only thing I don't think I saw mentioned was about not allowing the manufacturing. Would we write something in the conditions for that?
We don't need to because we already took the vote and that's in the findings of fact. So it's precluded.
Okay,
Yeah.
sounds good, Kevin.
Couple things I'd like to talk about.
Sure.
Use of marijuana on the property.
Right.
Can we put a provision in that there can be no use of marijuana on the property?
We
For,
can.
what do we call it? I mean, I don't want to put the word use and interfere with the manufacturing and the
Right.
processing and
Any recreational use.
Correct.
Right. It's already,
in the state.
it's in the state
Okay.
regs.
All right, then we don't need it
You
here.
can't do that.
Okay. And odor, we have here neutralized marijuana odor. Let's talk about it for a minute. There was a lot of talk about no odor. This is neutralized odor. I would like to define where odor can be determined a nuisance at the boundaries of this permit.
Okay, all right.
So-
Which is it? Is it 13C10E?
1310,
13C10E?
correct.
Yeah, okay. Chlorine dioxide generation system to neutralize marijuana odor.
So neutralized odor.
Okay,
If it's not there, it's not there, and that's what we were led to believe was going to happen here.
Right.
But let's define where it can be not there.
okay.
It can be not there.
But that's the tough part because there is no way to determine if it's there.
Oh, yes, there is.
Yeah.
No.
Oh, yes, there
Yeah.
is. The site plan.
No, how do you determine what smells? Just a
Who
human?
determines it?
Well,
Who, that's what I mean.
Well, according to the presentation that the applicant made to us a couple meetings back, the system works on odors both inside the building.
Right.
And because it neutralizes them before they exit.
That's right.
There won't be
Right.
anything outside. That's the plan, anyway.
And how do we do, I mean, you get a complaint, there's an odor.
Yeah.
Where do we test where that odor is?
I would think at the property line.
Well, that's what I think should be in the
Okay.
special permit, at the property line.
Okay.
Now,
All right, well, yeah, and you know, we can put that in under the conditions at this point. I mean, the findings of fact are just, you know, what has been presented to us. So if we want to specify that, then we can go ahead and do that.
I think that's a large concern from the community.
Yeah, yeah, I agree.
But what are we going to use to determine?
Are we getting ahead of ourselves, do you think?
Yeah, when we get to the conditions, we'll talk about that. Okay,
Yeah.
all right?
For section M,
Yeah.
on page 5 of the first item there, not detrimental to the public good or character of the town. It notes here that the majority of voters in the town of Brookfield approve the legislation of adult recreational marijuana facilities. And that's all true. The majority of the town did vote for that. But that's really the only criteria that's being used, that this particular project is not detrimental to the public good or character of the town. Is there anything else that we can say in there to justify that finding?
Well, I think that a public vote, both in an election and the vote for improvement of the zoning bylaw and the amended zoning bylaw, indicate that the feeling of the majority of the town is that in and of itself, marijuana cultivation is not something that is detrimental to the town. If the majority felt that it was detrimental, this town would not have approved it in the first place.
I believe that statement.
Yeah, but every other item in here is referring to the details of this project, whereas section A is referring to a past town vote.
Okay.
So is there anything based on the public hearing that you feel could justify that this project is not detrimental to the public good based on the findings that were, or the materials that were provided?
Right. I don't see anything that was presented that was in and of itself detrimental to the town.
And it's approved in the zone, so it's already kind of been looked at, like as Kevin said, by the whole town in front of the citizens that voted on it, that showed up at that point. They approved it in that area. And we kind of helped guide it to get to that area, so I kind of think that's why it's not detrimental. I mean, we kind of, we went out and we took a time to prove, or to at least make it so it wouldn't be detrimental, not allowing manufacturing, not allowing stuff like that, to kind of guide it a little bit.
We can say that specific issues that were raised in the consideration of this application were accompanied by plans for mitigating or eliminating all of them in that case. So, I mean, it's not that a problem that a presentation or an application has for use has problems. It's, can you fix them? Can you prevent them from happening? And I think that from the information that we were given, at least I believe that they can be fixed. Anybody else have any?
No, I think some of the paragraphs above lead to the questions and answers for below.
Yep. Yeah. So, I mean, I can add something in that oh, what, and then you have any, I don't want to put words in anybody's mouth.
I think it's fine. The townspeople voted it.
That issues were effectively answered by the applicant when questioned about them by the board. Okay, I'll write that down.
Okay. Yeah, my point there is, I think it would be worth stating something along those lines. Because all the other items in our section M are referring to the project specifically, not the use specifically.
Okay, so what I'm going to add is, issues with the proposed facility were effectively answered by the applicant under questioning by the board members. Work? Okay, all right. Moving on from there, the other parts of the 13C10 findings. Yeah.
Nope.
Nothing else said.
Okay, all right. Okay,
Oh, sorry, Kevin, I had one
Yeah.
more thing about, on page 6, 13C, 10C, traffic hazard and congestion. I believe there was some discussion during the meeting about guiding traffic leaving the property to turn right, if I'm not mistaken.
yeah, that's, I put something
Do you think that's
on
more of a
that under
condition?
the conditions.
Conditions.
Okay,
Yep,
sounds good.
yep.
That's all I got for section M then.
Okay, all right. Okay, so those are all the required findings, and they're met, according to what I've heard from you all. And then we have a number of conditions here, too, that I have proposed. Some of them are required by the zoning bylaw, Chapter 8G, or Section 8G, I should say, and others have been brought to mind by our discussions. So, so any of these conditions here that you'd like to amend or work more into or add to, there are 24 conditions. And,
Do you think it would be worthwhile to read through these
yeah,
conditions?
sure, I'd be happy to.
Okay, thank you.
So, number 1, permit holders shall comply with permit requirements of all municipal and state regulatory bodies, including but not limited to the Cannabis Control Commission, the Brookfield Board of Health, Conservation Commission, Highway Department, and the Town Inspection Services. 2, the permit holder shall comply with all federal, state, and local regulations, laws, bylaws, or other legal requirements with regard to the handling, storage, disposal, and cleanup of any hazardous materials, including but not limited to fluids generated by or used in equipment and vehicles serviced on the site. 3, accepting any requirements waived by the planning board during its deliberations on this special permit. The permit holder shall comply with the operational and other applicable requirements for marijuana facilities in Section 8G of the Brookfield zoning bylaw, as well as all other applicable provisions found in other sections of that bylaw and the provisions of 935 CMR 500.120, additional operational requirements for indoor and outdoor marijuana cultivators. And that section of the regulations covers a lot of what we've been talking about with reference to other state regulations for air quality, water quality, noise, etc. So it's a good section to read. It'll calm a lot of fears, I think. It did for me. Number 4. The permit holder shall submit copies of provisional and final licenses for marijuana cultivation granted by the Massachusetts Cannabis Control Commission to the Planning Board and the Brookfield Town Clerk within 14 days of their receipt by the permit holder. Or 5, the permit holder shall file with the zoning enforcement officer and planning board within 24 hours of creation a copy of any incident report as required under 105 CMR 725.110, parentheses F, close parentheses, and/or 935 CMR 500.110. Such reports may be redacted as necessary to comply with any applicable state or federal laws and regulations. 6, the permit holder shall file with the zoning enforcement officer and the planning board within 48 hours of receipt a copy of any summary cease and desist order, quarantine order, summary suspension order, order limiting sales, notice of a hearing or final action issued by the Cannabis Control Commission or the Division of Administrative Law Appeals as applicable regarding the marijuana facility. Number 7, the permit holder shall provide the police department, fire department, building inspector, board of health, zoning enforcement officer, and planning board with the names, phone numbers, mailing, and email addresses of all management staff and key holders, including a minimum of 2 operators or managers of the facility identified as designated contact persons to whom notice should be made if there are operating problems associated with the permitted use. All such contact information shall be updated as needed to keep it current and accurate. Number 8, the designated contact persons for the permit holder shall notify the police department, fire department, building inspector, board of health, and planning board in writing a minimum of 30 days prior to any change in ownership or management of a facility regulated under Section 8G of the Brookfield zoning bylaw. 9, the permit holder shall file an annual report with the planning board, and the owner or operations manager for the marijuana facility shall appear before the planning board to present the annual report no later than February 9th of each year, providing a copy of all current applicable state licenses to demonstrate continued compliance with the conditions of the special permit. 10, if contacted by a municipal official concerning the operation of the marijuana facility, a designated contact person for the permit holder shall respond by phone or email to any such inquiry within 24 hours. Number 11, this special permit shall be limited to the current permit holder and shall lapse if the permit holder sells or ceases operating the marijuana facility or is sold to or subsumed into another entity such that a material change in ultimate operational control or responsibility occurs. Or 12, this special permit shall lapse upon the expiration or termination of the applicant's registration or licensure by the Cannabis Control Commission. 13, the permit holder shall notify the zoning enforcement officer and planning board in writing within 48 hours of the cessation of operations of the marijuana facility by the permit holder or the expiration or termination of the permit holder's registration with the Cannabis Control Commission. Number 14, the hours of operation of the permit holder's facility at the property shall be Monday through Sunday from 7 a.m. to 7 p.m. Number 15, all raw and finished materials, supplies, equipment, and parts shall be stored indoors within the facility's head house and grow house. All marijuana waste materials shall be stored for disposal in accordance with the provisions of 935 CMR 500.105, Section 11 and 12. The permit holder shall employ and maintain in good working order equipment and measures to control odors, dust, and noise associated with marijuana cultivation in accordance with the dictates of 310 CMR 7.09 and 7.10 and the Massachusetts Department of Environmental Protection's noise level policy. 17, where the size of a vehicle makes direct access to the facility via the driveway impractical, Sun Fusions Incorporated or its designated agent will provide traffic management measures to include flagmen and cones and/or signs along Molasses Hill Road during loading or unloading of the parked vehicle for the safety of personnel, residents, and others traveling along Molasses Hill Road. 18, the permit holder shall not transport marijuana, marijuana products, marijuana waste materials, or equipment or supplies associated with this facility from the facility via Molasses Hill Road in a southerly direction. To the extent possible, the permit holder shall require vendors, employees, and contractors during construction and operation of the facility to avoid use of the portion of Molasses Hill Road south of the facility's access driveway. Number 19, signage for the facility shall be in accordance with the dictates of 935 CMR 500.105, parentheses 4, close parentheses, and otherwise subject to regulations specified for businesses in the Brookfield zoning bylaws, section 10.A.2, sign regulation, signs in non-business districts. Such signage, if illuminated, shall be lit by exterior lighting only and not illuminated from within, and placed on the property so it does not impinge upon the town's right-of-way. Number 20, the access driveway shall be gated at the property line with a sliding gate of a design similar to gates of comparable size used in residential applications. 21, during non-business hours, all exterior lighting servicing the marijuana cultivation facility shall either be turned off or be activated by motion sensors, so that such lighting shall not be perpetually in the on position and spill over onto adjacent properties. 22, following the completion of construction, the permit holder shall ensure that all structural components of the improvements on the site, including but not limited to fences, buildings, driveways, parking areas, stormwater management structures, and septic facilities, remain in a state of good repair. Number 23, this special permit shall lapse within 3 years from the date of filing of this permit with the town clerk by the board, unless it has been both recorded at the Registry of Deeds and substantial construction or use hereunder has commenced within that period. Otherwise, it shall lapse within 5 years from said filing date. If the permit holder wishes to renew the special permit, an application to renew it must be submitted at least 120 days prior to the expiration of the special permit. Number 24, the special permit shall not take effect until it has been recorded at the Registry of Deeds at the permit holder's expense. So a number of those were required by Section 8G, and others I just wrote based on what I heard here and what I've heard about other projects to try and make them as unobtrusive as possible.
The only one I don't really remember going too hard into was number 18.
Okay.
Was the required,
Right.
it's,
Well,
I know it says to the extent possible,
Well, I mean,
but it starts off with shall not transport, so I know that's just tough. Most likely they're not gonna go that way.
why would you?
You probably won't.
Yeah.
But I don't know if we have the legal authority. That's not really land use. It's not really in our purview. It's off property. It's a state road or a town road, however you want to look at it. I don't mind it fully in there, but I just don't know if that's really beneficial or to the project.
Well, I think it was agreed upon with the applicant,
Yeah,
so
there was that.
that was part of the applicant's.
And it did
Stuff-
address a lot of what the residents on Molasses Hill Road were concerned about, that there would be trucks rolling by.
I mean, the shipments, anything going out from the facility, except if it's a FedEx truck or something like that, is well within the applicant's ability to control. Think people coming in, well, if somebody on the southern end of Molasses Hill Road gets a job at the place, I'm not going to say they can't drive up the road. I mean,
No,
who
it's true.
would say that?
I still want to touch base on the odor control.
Yep.
And noise control,
Right.
because I did forward that information to you about DEP's. Now they have noise complaints from the fans.
Yep.
So,
Right, so that's covered in 16, in point 16, and also in, where was it? 3.
yeah, I don't know if it's strong enough language.
Okay, so what do you think would help there?
Well, first off, I think we have to determine if there was ever a smell, where the smell should be, at what point should the smell be determined? At whose property line, what property line, so it doesn't get out of hand.
Right, so it would be at the property line of the property
I agree.
where the facility is.
I agree, yeah.
So,
Yeah. You shouldn't have to, fight to determine, I can smell it here, and this is as far as you can go. And after that, it's on their property.
yeah.
But in there's no odor technology. That was the word from the applicant. There will be no odor, so I think that has to be emphasized. It's in there, but
Yeah.
I'm just not sure it's strong enough.
Yep.
And the fan noise should be directed away from the closest housing.
Well, you can't, I mean, that's changing the whole, I mean,
It's fans.
but that's changing it from one side of the building to the other, or to
Could
make
very
it-
well be, but you don't want a fan blowing towards your house all night long because they make noise. And it's
Boston goes by 50 decibels from 11 to 7.
all I
There's a
can
noise
tell you.
complaint, over
is-
50.
I have it on my phone from the
10
Cannabis Control Commission. That's one of their complaints they got recently.
I'm not doubting
So
it.
let's not slide by that complaint.
I'm not doubting it. I mean, this is in the middle of, this has got trees around it. If the fans, I think we set the limit, just like Boston does, 10 decibels over 50. 50 is the level from 11 to 7 in the morning. 70 is during the day. So, I mean, if you want to set those limits, and that would be from the street or from off property, I would say. That would be the number.
Well, the
Because otherwise, you're just picking a number, but that's at least hard data.
The
That's what Boston-
DEP has a noise level policy for, for this. Do we need to replicate the policy in this?
I'm just saying, if we're gonna put something in, I'd at least want it to be something hard. I don't want it to be, like an elusive boogeyman that, somebody can just pick it.
You're absolutely correct.
Somebody can pick it, and it's loud, it's constantly loud. No, I'm sure it might be, but if you have ACs outside your house, that's loud too. It's if we go by the standard, or I mean, at least Boston standard. I don't think Brookfield has an actual number in town. It's just.
But I do know if you direct the noise away from any houses, it makes a big difference.
Yeah, but that could be changing the whole the building layout. I mean,
So we're
we're
here
a
for-
little late in the game to start saying that now we want you to change your building layout to point the fans away. I'm not, because they were at the end, which is still away,
Okay.
but what's away is, because,
Okay, so this policy is basically what is written into our bylaw for, believe it or not, ground-based solar generation facilities. And the policy is a source of sound will be considered to be violating the department's noise regulation, parentheses, 310 CMR 7.10, parentheses, if the source, 1, increases the broadband sound level by more than 10 dBA above ambient, or 2, produces a pure tone condition, that is, whenever any octave band center frequency sound pressure level exceeds the 2 adjacent center frequency sound pressure levels by 3 decibels or more. And these criteria are measured both at the property line and at the nearest inhabited residence. Ambient is defined as the background A-weighted sound level that is exceeded 90% of the time measured during equipment operating hours. The ambient may also be established by other means with the consent of the department. And that has been in place
What do you
now
think?
for 35 years.
I mean, so at some point, you're gonna have to get out there and do an ambient sound reading?
Well,
because it doesn't set ambient.
I think if it's irritating, it would be obvious.
I know, but
Well, subjective.
it's very objective.
Yeah, it is, and there are ways to measure that, but, you know, and the ambient sound level varies a lot according to season and according time of day, too.
Absolutely.
I mean, the ambient sound in the spring is a whole lot louder than it is in winter.
Absolutely. The birds and the frogs and the peepers and the, I mean, you get out at night on the lake and it's loud as can be.
Yes.
It's louder than it is during the day sometimes. Same in the woods, right? You know, those things are loud. What do you think?
It's true.
No, what do you think about setting a number or leaving it kind of ambiguous so we have, I mean, I think it would just cause problems if we don't set numbers. If we're gonna put something in,
If you are going to put something in, I agree with putting something that can be verified is sensible. So if you can do some, I mean, what you were suggesting sounds right. I don't really have the background in that to really suggest a number, though. The 10 decibels over ambient, I mean, that sounded reasonable, but if is that state law, though, or?
That's state regulation from the state regulations. It's regulations 310 CMR 7.10.
Okay. So I think the only reason we would add something there is
That's
if,
exactly what they're referring to here.
Yes.
I think the only reason we would add something if we're setting criteria more strict than state law. If state law already covers that specifically, then I think we would leave it. But if we want to set more strict criteria, then it's worth specifying.
Yeah, this is about cannabis facilities. There was a seminar in Southbridge, and people were complaining about the noise. That's what they refer to that same chapter.
Okay, so here's the actual wording of the regulation in particular. So 310 CMR 7.10 noise. 1. No person owning, leasing, or controlling a source of sound shall willfully, negligently, or through failure to provide necessary equipment, service, or maintenance, or to take necessary precautions, cause, suffer, allow, or permit unnecessary emissions from said source of sound that may cause noise. 2. 310 CMR 7.10(1), which I just read, shall pertain to, but shall not be limited to, prolonged unattended sounding of burglar alarms, construction and demolition equipment which characteristically emit sound, but which may be fitted and accommodated with equipment such as enclosures to suppress sound, or may be operated in a manner so as to suppress sound, suppressible and preventable industrial and commercial sources of sound, and other man-made sounds that cause noise. 3. 310 CMR 7.10(1) shall not apply to sounds emitted during and associated with 1. Parades, public gatherings, or sporting events for which permits have been issued, provided that said parades, public gatherings, or sporting events in one city or town do not cause noise in another city or town. I think of fireworks.
Noise.
I'm holding the packs.
2. It should not apply to sounds emitted during and associated with emergency, police, fire, and ambulance vehicles. 3. Police, fire, and civil and national defense activities. 4. Domestic equipment such as lawnmowers and power saws between the hours of 7 a.m. and 9 p.m. And then 4. 310 CMR 7.101 is subject to the enforcement provisions specified in 310 CMR 7.52. Okay. So, and those aren't listed here, but it talks about what the fining process is, and appeals of fines and so forth. The DEP has established a noise level policy for implementing this regulation, which I just read a while back. The policy specifies that the ambient sound level measured at the property line of the facility or at the nearest inhabited buildings shall not be increased by more than 10 decibels weighted for the A scale, dBA, that's what it means, due to the sound from the facility during its operating hours. The ambient sound level is the sound from all sources other than the particular sound of interest, also known as the background sound level. The ambient sound measurement, a weighted sound level, is taken where the offending sound cannot be heard, or with the sound source shut off. The ambient sound level is rarely found to be constant over time and is usually quite variable. The ambient sound level is considered to be the level that is exceeded 90% of the time that the noise measurements are taken. The ambient sound level may also be established by other means with the consent of the DEP. The dBA unit of sound measurement is altered or weighted to reflect human sound sensitivity. For instance, for those frequencies of sound which humans hear very well, the actual reading is enhanced or increased in the weighting process. The weighted reading, therefore, emphasizes the frequencies best heard by humans and likewise de-emphasizes those sound frequencies which are less well heard. The guideline further states that the facility shall not produce a pure tone condition at the property line or at the nearest inhabited buildings. A pure tone exists if the sound pressure level at any given octave band center frequency exceeds the levels of the two adjacent octave bands by 3 or more decibels. The Massachusetts Department of Environmental Protection adopted this noise control regulation, 310 CMR 7.10, under the authority of Massachusetts General Law, Chapter 111, Section 142B and 142D. The noise control regulation is used to limit the sound impact of new stationary sources and to respond to complaints of certain excessive sound. The DEP noise control regulation can be enforced by local officials under the authority of 310 CMR 7.52. And here's that enforcement provision. Quote, any police department, fire department, board of health officials, or building inspector or his designee acting within his jurisdictional area is hereby authorized by the DEP to enforce, as provided in Mass General Laws, Chapter 111, Section 142B, any regulation in which specific reference to 310 CMR 7.52 is cited. Noise is defined in the regulations as, quote, sound of sufficient intensity and or duration as to cause or contribute to a condition of air pollution, unquote.
All right, Kevin.
You all right? You're overloading? There's only a little tiny bit left.
I think the point of it is, it's covered.
Yeah, it's
covered.
So this is pretty,
You brought it up.
comprehensive.
I know I did.
This is pretty
I know
comprehensive.
I did.
So, yeah.
So it's covered.
It's covered.
All right. So,
And
by
Kevin
reference
has
here.
it noted where it's covered.
All right.
Good job, Kevin.
Thank you. Google is my friend sometimes. All right. So we talked about all these conditions, I think. Anything at all that we're missing that should be included in this that isn't here already?
To revisit Bruce's note about odor, is there anything that we want to specify in there in regards to odor, given that was also a highly voiced concern?
Okay, so that's again covered by the Massachusetts state regulations, 310 CMR 7.09.
Yes, but we and the hearing participants very, very concerned about odor.
Okay.
So I think if we do our part to emphasize the applicant's words as to no odor.
Now, the one problem is how are we going to determine, well, a couple problems. One, how are we going to determine odor? There is no, I don't think there's a machine yet, right? That specifically, there's a number.
Yeah.
And then secondly, any neighbor on that street could grow 12 plants themselves.
You sure can.
They could each each neighbor, each house could have 12 plants. And at some point, when are we gonna say it's that neighbor or it's Sun Fusion?
Well, I think the point is, who's going to say it?
That's my other question. I think, I think he's taken the action. I think we can make general basis suggestions or notes, just like it's required by CCC, that they're required to mitigate odor by CCC standards. I think we go that route, because at some point, his direct neighbor could grow 12 plants, and he could be getting, or somebody across the street.
Yeah, but you go to North Brookfield, and you can smell it. Okay, so we're trying not to have that here.
Well, this is in the woods.
Yeah. Oh.
Well, it's,
Well, I think
if you,
really,
It's in the
the
woods.
distance,
really,
It's in the woods.
the distance from 67 down Winter Street to the facility is greater than the distance we're talking about to the closest neighbor.
I think that if there is a complaint of odor, then it should be strongest at the facility itself, because that would be the putative origin. If there is an odor and it is not, if it is present, but it's not stronger
true.
at the source than it is at the property line or at the nearest inhabited building, then it's probable that the source is someplace else.
I'm not saying it's not gonna be the source. I'm just saying there could be somebody right next to him.
Well, that has to be determined
Yeah.
if there's a complaint.
Yeah, yeah.
So are we gonna go through the neighbors' yards and determine if there's any?
No, we're gonna go through the applicant's yard,
Yeah.
Again,
because that's the place we'd have legal authority to do.
and according to the regulations that I just wrote about enforcement, that also applied to odor as well as noise.
Yeah.
So for example, the Board of Health would have the authority to check on this.
So let's
I
just
do
make
think-
sure we clarified what is odor. No odor, or very low odor, or,
It's to mitigate odor, it's not, there is no number.
You know,
And saying no odor is,
does mitigate mean lower the smell?
yeah. By CCC standards, he has to have a system that mitigates the smell. That's their
Does
job.
that mean lower the smell or eliminate the smell?
It's not, there's never an elimination.
Well, I think your post is something that he said there will be no odor.
Well, I think that means inside the facility while the product is in the grow house. But I mean, when it comes outside of the greenhouse, how would that system be able to mitigate the odor? So
Well,
they're
I
gonna- he's gonna-
believe, if I recall the public hearing, the odor is eliminated in the greenhouse. I'm not talking about the plant itself, the product itself, when you
Okay.
walk out the door
Yeah.
with a shipment of it.
Sure,
I'm talking about the grow house
yeah,
with these fans running. That's what I'm talking about.
okay, that's
And I,
reasonable. yeah.
and I do believe the applicant said it eliminates all the odor. And that's all I want to confirm and have it in the special permit process, is odor is eliminated.
So do you think wording along the lines of no odor is detected at the property line by persons with sensible sense of smell?
I guess it's going to have to be our zoning enforcement officer. This is part of zoning, right or
Well,
wrong?
actually more likely the Board of Health.
Okay. No, there she is.
Yeah.
She's smiling now.
Yeah, likely. Yeah, Massachusetts state regulations give broad authority to local boards of health.
Okay, so we only have to write in our part, and the Board of Health takes over after that.
Right.
So what is our part?
Well, I think that,
See what it says.
as it says here, the permit holder shall employ and maintain in good working order equipment and measures to control odors, dust, and noise associated with marijuana cultivation in accordance with the dictates of 310 CMR 7.09 and 7.10 and the Massachusetts Department of Environmental Protection's noise level policy. So,
I'd like a little stronger language.
okay, what would you like to say?
Eliminate odor. There will be no
Can't do
odor.
that.
Well, that's what he said.
Yeah.
That's what was said, odor eliminator. So if it's not detectable at the property line, we have no issue at all.
Okay, so how about apply measures to control and eliminate odors issuing from the facility?
From the greenhouse?
It's all one facility, so, yeah, and the
Measures
fans are
to
mainly in the, are
eliminate.
all in the greenhouse area.
Eliminate odors. Eliminate odors, or not, equipment and measures to control odors, no.
Mitigate?
Yeah, mitigate odors that can be detected at the property line.
To eliminate odors that,
Could possibly be detected.
that could be detectable at the
Correct.
okay.
Does that sound
extent
fair?
that they are undetectable at the property.
Yeah.
line.
That's
I don't
correct.
agree with that. I don't agree with that. It's changing the whole aspects of the thing. I mean, to say that you're not gonna smell it at the property, is a little crazy. And then somebody could just walk by and say, oh, I smell it. Next thing you know, this guy's getting a board of health up his ass for no reason. I mean, this is going.
So how do we do it? I mean, everybody in this room has a right to complain.
I totally agree. I'm not disagreeing that we shouldn't mitigate odor. What I'm thinking is saying no odor is asking for the police to be over there every day. That's just literally, we got 12 friggin' complaints about our meeting minutes. You don't think they're gonna call immediately with no odor? I mean, that place is it's gonna grow. It's growing, it's gonna smell.
Well,
It's gonna
therefore,
have some mitigation.
The
He's
direction
trying
of
to
the
do his best. We
fans, the
talked to
direction
him.
of the fans for the facility would help that greatly.
It's not, no, so the fans aren't supposed to remove air. They're not removing air.
Oh, okay.
They're heat
What comes out of the fan, we
Exactly.
turn it on then.
Exactly,
Like a heat exchange system.
yeah.
But they will have
Filters.
both particulate and carbon filters. And
Correct.
Carbon filters will pick up.
Well, I don't know how you're gonna satisfy the public if the place starts to stink and we have no recourse to,
You know, that-
No, we have recourse. We have the Conservation Commission that states that they have to mitigate the smell, and if they have problems,
You mean
that's
Board of
what
Health,
gets
right?
addressed.
You mean Board of Health, right?
What's that?
You said conservation, you meant
I mean,
Board of
yeah,
Health.
sorry, CCC.
yeah. Yeah.
well, let's vote on how you wanna write it in there then, because
Well, I'll just take a consensus view of this.
I want it written strong.
Yep, okay. So what do we say? To control odors such that they are undetectable at the property line?
That's how I would write it, that's how I would like it written.
That sound good?
Well, I mean, Chris does have a point about, any citizen can grow 12 plants.
Yes, they can.
Well,
when-
but that's a different source. If there's a complaint about an odor and it's found not to be emanating from this facility, then it's not the facility's fault. It's somebody else.
But why are we holding him to higher standards than the neighbor? Just because he's got a license?
Because it's a commercial venture.
Yeah.
And it is done via special permit, whereas the individuals are not required to have a special permit. to
And
grow
because the
plants.
applicant said throughout the whole public hearing process, odor eliminator.
I'm not gonna speak to what he exactly meant, but I've worked
Well,
in these
read
places.
it.
I've worked in these places. You can't even get in the front door.
But just read
without
it.
smelling it. It doesn't matter what system they have. It's not gonna eliminate it. You could pour anything in the air, nothing's gonna take it out of the plant that sticks or that smells. That's still there. Like, we have to understand there's gonna be some
I
smell.
am not a specialist in this. All I can tell you was presented to this board.
Yeah, and I tend, having looked at other sources of this same technology that are actually marketing it for this purpose, I tend to have a lot of credence for the applicant's presentation that it will effectively neutralize all the odors, provided that it's installed and operating properly. You know, like anything else.
Well, based on the proposed efficacy of that technology, the chlorine dioxide system, it seems reasonable to set some more strict guidelines on odor detection at the property line.
Okay. Yeah.
I don't think it's asking for too much because
No.
I think that's what was promised to be effective. Otherwise, the place would be shut down, I believe was the paraphrased
Yep.
statement.
Well, I'm pretty sure with the residents of Molasses Hill, it'll be shut down if we put no smell at the door. I mean, that's just,
Well, they're not gonna be able to shut it down.
yeah, they're gonna raise hell.
The Board of
I
Health's
just
gonna
don't agree
receive
with it.
complaints.
Zero smell when the neighbor can grow plants. Every neighbor can grow. And then you're gonna say zero smell, and you're gonna try to say it's him or her. And I mean, the guy's putting his thing a quarter mile back in the property. You know, it's like
All
you
the-
said, it's the best setup as it could be. It's as
All the
best
more
as it
reason it shouldn't smell.
could be. Yeah.
Okay. So,
My vote would be, or my strong disapproval, which I didn't think this was on the board. This is definitely changing.
Okay.
The aspects of the submitted paperwork that we have. It's kind of,
No, I think you're absolutely wrong.
I think it's
Sun
reasonable.
Fusion's paperwork was all about odor control.
Yeah. Yeah. I mean, the applicant stated a number of times that he knew that this was the biggest bugaboo in the whole
I know.
system. Anyway,
So the expectation would be that there would be no marijuana smell at the property line at all, ever?
Yes, I mean, obviously, if you're transporting the product off the property and there's an odor in the box that comes in, you know, but emanating from the building on a regular daily basis, no odor.
If you say no odor, if somebody drives off and there's an odor going down the road, I mean,
yeah.
Well, that would be a passing odor, then it
The
wouldn't be there.
regulations are
So
pretty
you're talking
specific
about a
on
prolonged odor.
how
Yeah,
the material
odor
is
emanating from the
transported.
Persistent
In
and
such
so
that
forth. So
it's
perhaps
like
we put
going through an
language like
airlock.
that.
Yep.
From the
Persistent.
building to the
Could be. I
van
don't
or
know
the
if
truck
Brookfield smells more
to
sometimes
wherever
than-
it's
than
going,
other
so
times.
that it's
You know
never
more than I do.
exposed to the outer
Your mom lives
air.
there. No?
So it's, it's highly unlikely
distance, I
unless
No, it
somebody
smells from across the
stumbles and
street.
breaks open a crate
It's
of
private use,
marijuana or
but
whatever.
that's what it is.
Anything's going to get out. And even that is, it's just the raw vegetation. It's nothing refined.
I guess what I'm saying is if we don't put some type of strong language in there, what's to stop the applicant from just turning it off?
Well, I think that, it's already required to keep the equipment
In rest-
maintained and
yeah.
in good working order. So if it's in good working order or not, and it's turned off, well, then there's going to be smell. That's a given.
I just think it's worthy of a strong
Yeah,
message.
so what I've suggested here is that the permit holder shall employ and maintain in good working order equipment and measures to control odors such that they are undetectable at the property line, dust and noise associated with marijuana cultivation, etc.
I think it's too strong.
I think that's sufficient.
Yeah, I do too.
Yeah.
hold on one second. Sorry. trying to find it in the 500 CMR, 935 CMR 500.
Yeah, 500, what are you looking for?
The odor control area. It's like 103.
Okay. No, it's like 120, under additional requirements for marijuana cultivators.
What does it state exactly, do you know?
I don't know if I can look at it. It's pretty long.
Yeah, it's 100. I don't know if I got the old one in the 2021 revision.
Okay. Yeah, okay, so here, it just so happens I have it up. Additional operational requirements for indoor and outdoor
Okay,
marijuana
yeah.
cultivators. Let's see, I found this one. Nutrients. They talk about, you know, fertilizers and pesticides in here too. Okay, it's 500.120, section 11. Marijuana cultivators shall satisfy minimum energy efficiency and equipment standards established by the commission and meet all applicable environmental laws, regulations, permits, and other applicable approvals, including but not limited to those related to water quality and quantity, wastewater, solid and hazardous waste management, and air pollution control, including prevention of odor and noise pursuant to 310 CMR 7.00, air pollution control, as a condition of obtaining a final license under 935 CMR 500.103, parentheses 2, and as a condition of renewal under 935 CMR 500.103, parentheses 4. So the odor and noise have to be controlled in order to, A, get the license. So they have to accept the plan, and they have to see that it works, or evidence that it will work. And number two, it has to actually work in order for them to get a renewal of their license.
This is the state.
This is the
So it
state.
just says prevention of odor.
Yep.
Prevention. Doesn't say total elimination. Doesn't say,
I'm not saying total elimination, I'm saying at the property line.
Odor and noise pursuant to what
says
the...
Because that's what the applicant stated. In my mind, that's what was stated.
no, I don't, that's not what the applicant stated. He didn't say it was gonna smell zero at the property line. I don't think that's ever
No,
come
he
up.
never mentioned property
Well,
line. He
he-
said there will be no emitting odors. It eliminates odor.
Yeah,
And he said that there would be no odor in the facility. That was
So
his
I'm giving
experience.
some
at the
leeway.
facility that he's...
I think this is opening up for a can of worms if that's what we put, but
You know,
I'm just one vote.
You know what? I think that if it works the way it's been presented to work, then there won't be any smell on the property line, not for this facility anyway.
Yeah, and I think that wording, eliminate odor at the property line, is a good way to phrase it, because a 935 CMR does use that wording for reference to consumption sites.
Yeah, yeah.
So I think that wording is fair, but I think for this application, if we want to have something that's going to protect the public from offensive, dangerous, or harmful odors, I mean, I think
And
it's
in
within...
general, that provision is also generally in our zoning bylaw too, not just in the special permit.
Chris, would you feel more comfortable if it said it shouldn't be prolonged or persistent? Like if, you know,
I think the word zero, like, you're pretty much saying zero. I think that's just unexpected. That's unattainable reality. It's not going to happen. I've worked at these facilities. I've never walked up to one and said, there's not a facility here.
Well, I can remember the applicant saying to me, and I believe he said to you too, would you like to go to a facility that has no odor?
And I said no.
And I did too.
Yeah.
And I said
But I still believe what he said.
I can tell you, it's not, zero is an unattainable expectation. In life, there is nothing zero.
Well, the other things that they said too were that A, it's new, which it is, relatively speaking, and B, it's expensive. So a lot of facilities, retail facilities in particular, are not going to invest in something like that because their profit margin is already fairly low compared to what I'm told the street price of this stuff is. I don't buy it myself, so I don't know. But that's what I read in the papers.
That's what you heard on the streets.
That's what I heard in the street, yes. All right. So if
I think there should be some leeway, but that's just my statement.
I think that this provides some leeway here.
Property line,
Property line.
200 feet away from the property line on top of that.
Yeah.
So,
And that's in keeping with the wording of the regulations too. So, all right. Anything else among the conditions? Anything that you feel needs to be explained because it's not clear?
I'm good.
Okay. All right. All right. So then we need to have a properly motioned vote on whether to grant or deny this permit. From what I'm hearing from everybody from the discussion, the mood seems to be to grant it, but we need to have an official vote. And in order to grant this, we need a supermajority. That means 4 out of the 5 members present and voting here have to approve this permit for a marijuana cultivation facility in order for the permit to be granted. If we only get 3, while it's a majority of the board, it's not enough to grant a special permit. Okay, all right. So does anybody want to make a motion to grant the applicant the special permit for a marijuana cultivation facility?
I'll make that motion to approve the Sun Fusion's special permit for 6 Molasses,
Marijuana cultivation facility.
marijuana cultivation at 6 Molasses Hill Road.
Is there a second?
I'll second.
Okay, it's been moved and seconded to approve the special permit for a marijuana cultivation facility applied for by Sun Fusions Incorporated at 6 Molasses Hill Road. All those in favor of approval of the special permit, please signify by saying your name and aye.
Chris, aye.
Lisa, aye.
Bruce, aye.
Kevin, aye. Steve? Opposed?
no, Steve abstained.
Abstain. Okay. All right. So we have 4 in favor. The permit is granted with the 24 conditions that we've added on here. And hopefully this all works out as planned. So now we just need to generate the final document as we've amended it and sign that. What's your pleasure? I can probably do that tonight, and we can sign it because we're going to be taking up an issue that I can't participate in shortly, so I could handle it during that period of time. So if that works for everybody, I'll try and do
You're
that.
gonna have to leave it someplace for me to sign.
Yeah. Well, we can sign it tonight, because I've got a printer here, so.
Yeah, I'm not sticking around another hour though.
Oh,
I have
Okay,
no business here
all
after
right,
this.
all right, well, okay, all right. Well, let me print out the last page, and you can sign it. How about that? All right, so back to the agenda then. Under new business, there's a special permit application, and this is the one I can't take part in because I'm on the board of directors of the applicant.
Quick question.
Yes.
We're just going through it, approving it, and for next, setting it up for a special.
Right, we need a public hearing
Yep.
for this, just like every other special
Yep,
permit.
that's what I thought.
And so we're just receiving the application, make sure that it's complete.
Yep.
and then schedule the public hearing.
Yep, okay.
All right.
Cool.
Okay.
Thank you, sir.
You're welcome. Thank you.
All right. Are we gonna need Bruce, though?
No, not for this.
We'll have a quorum. Three is,
I was only held over for this.
Yeah, but my question is, because
Application.
if it's a special permit, we'll need him for the 4th.
Yeah. Yeah.
So should he be here for this part, or does it not matter?
We're gonna need
I know.
to either get a new permanent member or another associate.
Yeah, okay. And I saw that in the later
Right.
minutes. I just wanted to make sure.
Through the selectman's office, it was to, through this board, it was to fulfill the seat for the Sun Fusions application.
Correct.
That's what it was for.
Correct. All right. My name's Chris Gorman. I'd like to hear a motion to, I guess, seat me as the chair.
I will make a motion to seat you as your chair.
Second?
did you second that, or are you asking for a second?
Yeah, looking for a second.
Second.
Thank you. All in favor, state your name and I.
Steve, aye.
Lisa, I.
Chris, I. Okay, so we got an application for a special permit for Apple Country Radio. We have the check from Mike Siri, which we'll pass on, $250. $250, is it normally $250 for the special permit?
It's $250.
Okay.
Plus postage, which I have with me.
Okay, cool. All right, thank you. So we have the application for the special permit, Apple Country Radio, Inc., P.O. Box K300, Brookfield, Mass., 01506. The landowner of where you're gonna, I'm assuming is your new address?
Yes.
Is that what it is? 6 Central Street, which is the town hall. We have Miss Sharon Mahoney here from Apple Country Radio. I have a copy of the check. I got some paperwork here stating what you're requesting. Do you want to read it? Do you want me to read it for you?
I can read it.
Yeah, if you want.
I'm talking all night, so I can spare you that. To the planning board, July 31st.
Hey, Chris, can you have her use a microphone so it can be heard?
Oh, yes, thank you, Chris. Sorry, duh. Is the microphone here? Here it is. Fortunately, we have to have discussion on how to use it. Can you hear me, Chris? Chris Kelleher?
Yes,
Okay.
thank you, I appreciate it.
Thank you for the good work. July 31st, 2025, to the Planning Board. Apple Country Radio, Inc., a nonprofit educational corporation located in Brookfield, is submitting our application for a special permit to operate an FCC-licensed, nonprofit, all-volunteer, community, low-power broadcast radio station from rooms located in the Brookfield Town Hall, as described below, and in the documents accompanying this application. Planning Board Chair Kevin Erkola, a member of Apple Country Radio's Board of Directors, will be recusing himself from discussions and deliberations for this application, which he has done. We approached the town of Brookfield, and when I say we, I mean the corporation, approached the town of Brookfield about relocating in the town hall because Gavitt Wire and Cable, who had donated space to us in its former office building at 20 Central Street, had notified us in June 2022 that they would be putting both the factory and adjacent buildings on the market, at which point we abandoned plans to finish building out our live broadcast studio and began looking for a suitable space to locate both our studio and broadcast antenna. After a fruitless months-long search of privately owned properties within the FCC's allowable geographic parameters for our transmitter, we approached the Select Board and began negotiations to place our antenna on the Town Hall clock tower and to rent unused space in the Town Hall second floor. After much discussion and with the help of Town Council's contract templates, The Brookfield Select Board signed agreements with Apple Country Radio on April 3rd, 2025 to mount our antenna on the Town Hall clock tower, locate our transmitter and supplies in the mezzanine, which, in case you've never seen it, is a tiny room above the green room, which is in turn the adjacent room to the ballroom stage, and build out a live broadcast studio in the green room adjacent to the second floor Town Hall ballroom. Once the Massachusetts Historical Commission confirmed that the placement of our antenna on the clock tower would not interfere or jeopardize the town's eligibility for historical grants, the Brookfield Historical Commission voted to permit us to locate our antenna there. Copies of those documents, along with floor plans, are included in this application, as well as our federal and state licensees and corporate documents. A list of those documents is included in this special permit application. As part of our agreement with the town, Apple Country Radio will share these two spaces with Brookfield Community Arena, the town's cable access video organization, which has surrendered its own longtime studio space back to the Brookfield Elementary School. And we look forward to working with them to produce and/or simulcast programming of interest to town residents. Of note is that the so-called mezzanine, a small room midway between the town's hall's second and third floors, is essentially a large closet and had been used as such in the past. The stairwell to the mezzanine does not conform to modern building codes, and the room only has one exit, rendering it unsafe for anything except storage. We plan to locate our transmitter, there's my Boston accent, our transmitter, media storage, and excess equipment in that space alongside Brookfield Community's Arena's server, equipment, and supplies. To date, Apple Country Radio has made improvements to both spaces at considerable expense, including paying about $4,900 for wiring supplies that students from Tantasco's electrical department needed to install modern lighting, circuit board, and internet connectors in both rooms. We also paid $1,275 to refinish the worn and dirty wooden floors and stair treads in both spaces. We hope to repair, plaster, and paint the walls and ceilings in both rooms as well. This is in addition to the approximately $6,000 to $8,000 it will cost us to transfer the antenna to the town hall and build out our live studio and proposed internet streaming equipment. I've tried not to overwhelm you with paperwork for what should be a straightforward application, but if you require any more documentation, I'll be happy to provide it. More detailed information about the station, its mission, its broadcast reach in the Brookfields, and about low-power stations in general can be found at our website, applecountryradio.org. We hope the Planning Board will approve Apple Country Radio's application to operate from the Brookfield Town Hall and enable us to continue its mission to provide free, accessible, entertaining, and informative programming, including news, music, public affairs content, and emergency announcements for Brookfield and the surrounding towns. Sharon Mahoney, President, Apple Country Radio Incorporated, WACF-LP 98.1 FM. I trust that's complete enough of a statement.
That's very good.
I have here a check for the estimated postage based on the abutters list, which was given to me yesterday. Mm-hmm. I also have already taken the liberty of filling out all of the certificates of mailing for Holly so that she doesn't have to spend time doing that work. And I also have a set of extra labels for those towns adjacent to the town so that you don't have to write those envelopes out as well. And I am going to give that to you right now. Also, if you'll bear with me, Mr. Chair, the document I just read was a late draft which omitted the last sentence. So what I'm going to do is swap it out for a new copy. That's it, that's it.
That's the 25 one.
Yeah. So there's a fresh copy.
31.
Thank you. And here's another fresh copy.
Thank you. Yeah, so along with all that information, she has provided us with, as she said, the assessor map of abutters. We have the license agreement from the town of Brookfield to Apple Country Radio, WACF-LP. We have the Commonwealth of Mass Articles of Organization for your state identification number. We have the annual report listing all of the members. We have the FCC, what is this, Authority of Communications paperwork that is consent for WACFLP.
If I could explain what that is?
Yes, ma'am.
The license was originally issued to Appleseed Incorporated, a now defunct town board. When that organization decided to cease operations and disband, they gave us written permission to apply to have the license transferred to us, and the FCC concurred, hence the document you're holding now.
Yeah, from Appleseed to Apple Country. Awesome.
That's correct.
Okay, and we have the paperwork. Then we have the land use regulations, which is a requirement for TV, radio, special permit, planning board takes care of that. We have IRS paperwork for, this is your status, I'm assuming, for
Yes, that's
public
our
charity.
Our 501c3 status, that's
Yep.
correct.
Then we have another licensed agreement. And then last one is, the historical for the approval.
Right, Mass Historical Society.
Yep, for their approval on the antenna location. All right,
Right, there's also the two license agreements the town has signed with us on April 3rd, one for the antenna and mezzanine and the other for the green room.
yeah, okay, that's what that second one is.
That's correct, and they
Okay.
include floor plans for both rooms.
Yeah, and I do have floor plans, I'll actually pass them so you can kind of give it a look if you haven't been upstairs. That's what it looks like originally. And then the one before is the layout of the room.
And as I said, we'll be sharing that space. If this permit is approved for us, we'll be sharing the space with Brookfield Community Arena. We've already worked out how the floor plan for that would work in that case, so that we won't get in each other's way and we'll be able to work together.
And the special permit was signed by Mike Siri as well, a couple days ago, that he received it. Thank you, ma'am.
And I'd like at this time to formally request a public hearing for your next meeting in September.
Yep, that works. September, I think it's, is it early?
I believe it's September 3rd,
It's early,
first
yeah.
Wednesday of the month.
Yep. Yep. We'll set that for 7 PM standard.
Do we typically do public hearings 30 minutes after the meeting begins?
6:45, 7, it depends what, we can set it for whatever.
I think we could set it for 6:30, and we can hear it as soon as available. I mean, so long as that works with the applicant. Because sometimes, because if we set it later, we can't hold the public
Yeah.
hearing until that time.
Yeah, that's
But
right.
if we don't have 30 minutes to fill the agenda, we could hear it sooner if we set it to 6:30.
Yep, 6:30.
Fine by me.
Set it for 6:30.
And I'd like to stress, if any more documentation is needed, I'd be happy to provide that.
I think you got pretty much all covered.
I believe in too much information rather than not enough, so.
All right. Do we need to, I think that's pretty much it. We'll set it for next meeting. And I'll pass this back to Mike. That's it.
I also want to mention that the Select Board has agreed that we have begun work on the spaces, again, at our own expense, that we can continue doing that work. The only thing we can't do until the permit is issued is to actually broadcast from those spaces.
Yep. Yeah, no, you already spent money doing it. I mean,
Because that was their rationale as well,
yeah.
so.
And it's definitely benefiting the town. I mean, I can tell you, my neighborhood listens to it, so.
I listen to it.
Right, for coordination purposes, there are some tasks that we need to do as a board,
Yep.
such as posting the legal ad,
Yep.
and also providing those documents so they're available for review And it's not necessarily required, but we often will post them on the agenda on My Town Government. And Kevin does a lot of that work. So with his recusal, we should have a plan for how we're going to cover that in his absence.
Steve, I might point out, I gave 2 copies of this entire application package to Mike, and I believe he still has one in the office for
Okay.
public.
For public review?
Yes.
Yeah, I'll talk to Mike. I don't upload, I don't know anything about
I mean,
the town.
I'm volunteering, I'd be happy to.
Yeah, by all means, I have no problem with you jumping in.
Okay. And then the other side would be posting the legal ad.
Yep.
So I've done that for the Conservation Commission.
Holly, I know you took those the butters lists. Do you do the legal ad too, or no?
I can.
It's up to you. I'm happy to take it too. I'm familiar with the process just from conservation. So
If you don't mind?
I don't mind. No.
I don't mind having you do both of those, that'd be
Okay.
awesome.
So that'll be the scope of my responsibility
Yep.
as of now. I'll scan in those documents and make sure they're available on the agenda and post in the legal ad.
Yep, sounds good, I appreciate that.
Yep.
Thanks,
Thank you.
Steve.
Yep, sure thing.
Thank you. Yeah, I think that's it.
Thank you.
Thank you very much,
Thank you.
Karen.
Thanks.
You're the best.
I'll give it to Mike afterwards.
Chris, can I see that check so I can turn it over?
The what?
Is there a check on that so I can turn it over?
Oh, yeah. Thank you.
There's already a copy of the check in there.
Okay, thanks.
Thank you all.
Thank you.
Thank you.
Let me pull up the agenda.
Do you want a copy of tonight's agenda? Is that what you're looking for?
I was just searching for it.
And thank you very much, Chris.
I'd like to make a motion to seat Kevin as chair.
I'll second.
All in favor?
Chris, aye.
Steve, aye.
Lisa, aye.
Kevin, aye. Okay. Okay, so then this brings us to the process for filling open planning board seats until the next town election. With the death of Mr. King, we do have a regular board member slot open. Are you Ms. Santucci?
I am.
Okay, so Ms. Jennifer Santucci, who has expressed an interest in being a candidate for the open planning board seat, the process for doing that, since it's an elected position, is that the planning board can nominate someone, and then both the planning board and the select board have to meet in a joint meeting to elect that person who will serve until the time of the next town election, whereupon if they want to, they can run for the remainder of that term, or if there's another seat open, they can run for that seat for a full 5-year term. So it's just a matter of us deciding if we want to nominate someone, and then we have to engage with the select board to set up the time to actually have that joint meeting. It could be part of our next regular meeting, for example. Ms. Santucci's actually provided us with a little background on her experience and orientation to the town, too. See, originally from Smithfield, Rhode Island, attended Johnson & Wales University, and you've worked in real estate law
Yes.
for a while. Yeah.
Yep.
Okay.
Since 2014.
Jake's going to provide
Sorry.
That's okay.
I've worked in real estate law since 2014.
Okay, great. Have you had much to do with zoning?
Yep, so I worked for a couple different law firms where I represented clients in front of zoning and planning boards.
Great, great. So, well, that would be very helpful to have someone with that experience on this board, really, because a good chunk of time that I spend is just researching regulations and laws and bylaws. So that would be helpful. You're relatively new to Brookfield. Is your husband born here or has lived here for a long time?
So he is from Western Mass, and at the time I was working in Worcester, so we wanted to find a nice town where we could settle down and raise our family, and we loved this area and we loved the town.
Mm-hmm. Great. Okay, so relatively new. How are you finding the area so far?
We love it here.
Good, good. Yeah, it's great. It's great. Anybody have any questions for Mrs. Santucci at this point?
I read her letter. I think she's very qualified.
Then you also noted this is where your passion lies, and having passion for such a thing is, I think, more than welcome.
Yeah. So, yeah, we have a pretty varied background here among the other members of the board right now. Lisa's a real estate agent. I'm a retired engineer with a medical electronics firm. Chris is an electrician specializing in fire alarm systems. And Steve?
I'm a web developer, and I volunteer wherever I can.
That's great.
So a lot of passion for good government. Great. Okay. I think you're a viable candidate. If we nominate you and you're elected to the position, think you'll serve on that?
Absolutely.
Absolutely. Okay. All right. Great.
I have one question.
Yes.
It's not.
Oh, no, run.
It's nice and easy. Are you looking to run just for the 2-3 years for the open seat?
It'll be another 4 years.
It is because you just got on. That's right.
Just got on.
Okay.
Yeah, I would.
That's what your plan is?
Yeah.
All right, good. I just wanted to make sure you understood it was like a, yes, not a 1 year. Hopefully we got a couple good ones out of you.
Mm-hmm.
Yeah.
Okay, good.
Yeah, that's my plan.
It's okay. Great. All right. Super. Okay. Well, thank you very much. I think shall we nominate her right now and take a vote? Nominate her right now. Might as well. That way we'll have to redo the nomination formally in the joint meeting with the select board. But do I have a motion to nominate Jennifer Santucci to fulfill the unexpired term of Mr. King?
I'll make a motion to nominate Jennifer Santucci to the open seat of Mr. King.
Is there a
Second.
Okay. All in favor, please signify by saying your name and aye.
Steve, I.
Chris, aye.
Lisa, I.
And Kevin, aye. Thank you.
Thank you.
We'll be in touch.
Thank you.
All right. And now the town's delegate to the Central Massachusetts Regional Planning Commission. We have to elect him. Currently, it's Chris. Would you be interested in maintaining that?
I can. I think you'd probably get more use out of it, but if I did enjoy our last meeting we actually just had. Mm-hmm. It was kind of interesting sitting with Brookfield, Boylston and North Brookfield people.
Yeah.
Very interesting. Yeah. If you, I know you love doing stuff. If you definitely want to, by all means.
I'm happy to be the alternate,
Okay.
which is what I am right now.
Yeah, no, then I'll stay doing it. I don't mind.
Okay. Any other nominations? No? Okay. All right. So, let's have a motion to elect Chris Gorman as the town's delegate to the CMRPC.
I'll make a motion to nominate Chris Gorman as our delegate for the CMRPC.
Is there a
Second.
Okay. Any further discussion? All in favor, signify by saying your name and aye.
Steve, I.
Lisa, I.
Kevin, aye.
Chris, aye.
All right. Congratulations, Mr. Gorman.
Thank you, sir.
All right. Right. Moving on to financials, not a whole lot. We have the last report from the accountant for the end of fiscal '25 and the first two for fiscal '26, in which we have not spent any money yet, so our expenses are at zero at this point. And in fiscal year '25, we spent 90% of our planning board salary and about 66% of our expense line, so it wasn't too bad. The total expenses for the year were budgeted at $2,000, which is what they're budgeted at for this year too. So we get by with that. Any comments or questions on the expenditure reports?
No.
Okay. All right. Moving on then. So we met as a board on July 22 to decide on how to reply to the 7 open meeting law complaints that we've received. And I report that I generated the replies as we had discussed them. And they all went out in time to meet the deadline for those. So I have had one person get back to me with concerns about when the modified meeting minutes, the expanded meeting minutes from the April 9th meeting would be available, because they were concerned in case they wanted to appeal the board's decision on the special permit. So I discussed that with that person, and the upshot is that even if they did file an appeal, it wouldn't be handled immediately by the land court, because it always takes time for these things to happen. So it's unlikely that there would be a problem if they needed those minutes for the land court proceedings. However, if it changed up, we can probably meet their needs in one way or another. I mean, we're pretty flexible overall. So that's it. At that meeting on 7/22, at the end of the meeting, I was presented with an open meeting law complaint about minutes of the meeting of May 7, 2025. The gist of the complaint is basically the same as those complaints about the April 9th meeting, that the minutes were insufficiently detailed, and the complainant's action that they want the public body to take is the minutes should be amended to accurately document what happened during the meeting, so that anyone who reads the minutes can understand what happened. I believe that in approving the corrected, expanded minutes for that meeting that we did this evening, we met this standard. It does seem to answer a number of the points that are raised here that are relevant to the open meeting law, and there are 6 points that the complainant raises. One is that the meeting was video recorded by the town and posted to YouTube, but the minutes state that they were only audio recorded for the purpose of the minutes. Okay, well, this board does not control the video recording by the town or anybody else. If the town wants to record it, they can record it, as can other people. But we do have to announce whenever we have an audio recording going on, because it's harder to identify people by audio alone. And that's the law. Number 2, the minutes are not detailed enough to document what happened in the meeting. So we've addressed that. For example, the odor control discussion and discussion on manufacturing was extensive, but is only bulleted in the minutes. Okay, so that was all expanded in the draft that we approved tonight. 3, the minutes mention a letter from the applicant's lawyer intended to dissuade a new planning board member from voting Discussion of this is not summarized. Applicant, in fact, interrupts the chair. Yep, and the minutes do not accurately reflect this discussion. So they do now. 4, I could not locate any record of such a discussion by the planning board meeting to make a, oh, I see, what the discussion that is referred to is that the chair reads off the lawyer's letter and then also his own response where he states that the board has recommended that Bruce Clark remain on as an associate member. And they say, I do not locate any record of such a discussion by the planning board meeting to make such a recommendation, so it's not clear. I was advised by town council that I had, as chair, the ability to make this recommendation to the select board. It's only a recommendation, it's not a nomination, it's not a formal vote taken. And because it is a recommendation, the select board did not need to take it, but they did. And for reason that I stated, is that Mr. Clark had already been involved with the first session on the special permit, and it would be good to have that continuity going forward. And the minutes state that Carmen publicly opposed the project, but others on the board have made statements that they clearly support the project, and these are omitted. Well, they're included now. Arcola then summarizes Carmen's letter, which the minutes say is attached, but it's not, and that's true. But nor is listed in the list of documents. Actually, it is listed in the list of documents. And I can point it out to the complainant if they want. And then the minutes do not reflect important discussions such as that the chair asked Carmen if he felt he should recuse himself, to which Carmen responded that he did not feel that he should be recused. Okay, so that discussion was now reflected, I think, in the expanded minutes. To your satisfaction, Steve?
Yeah, I think that conversation that we had during that meeting was a little bit vague in a sense too.
Yeah.
With the context provided that you are a 5-member board, including an alternate, to make a decision on that special permit, the decision I don't think necessarily was to ask me to recuse myself in a sense, but to not be a voting member if there was a 5-member board to participate. So I think the conversation in that meeting wasn't clear in the first place.
Right. Yeah,
But-
and I apologize. It wasn't really clear at that point in time exactly what our best avenue of procedure ought to be. But in subsequent conversations with town council, we were able to work that out. And then, of course, Mr. King died, which actually opened up more room.
Sorry.
Yeah, but I think the confusion did linger past then because there were some references to me recusing myself, and I never did recuse myself,
No.
and the minutes do not mention that I recused myself.
Yeah, and if
which
you
is
listen-
correct.
Yeah, and I listened to the recording. I didn't hear anything about recusing yourself on that. So,
Yep.
I mean, but you did, not that it matters, but you did step away from the proceedings pretty much. You weren't a listed member at that point. I mean, we could say that, but that's here nor there. My question is, this is the 8th open meeting law. How much of that is actually open meeting law material? Is this just wasting our time yet again by another one of these?
if it improves people's confidence in that we're trying to do the right thing, I think it's worthwhile. And, it takes a lot of time to do this, and I'm willing to put in the time if necessary to expand the minutes to give people the sense that we're not hiding something.
I don't think we're hiding it. We got a camera rolling that anybody can pull it up. We have minutes that technically satisfy the open meeting law. At no point does it say you have to say what Steve Carmen exactly said, what anything exactly said. The only you could say is it was a little vague, but that's not a requirement in the law. So, I mean, at some point, I mean, if we just keep getting these, this is just wasting our time.
I wouldn't,
This is the
Yeah.
third month of getting these.
yeah, no, I think we've settled on the standard, and we're going to carry that standard forward. So
Yeah,
that's,
good.
that's, you know,
Yeah, and to the complainants, or in favor of the complainants, the meeting minutes should accurately summarize the meeting so people who did not attend would have an understanding of what took place. So if there are particular line items that they call forth in their complaint, which in reference to the minutes are omitted, I think it's not too big of an ask just to amend the minutes to include that.
It's not amending the minutes, it's an open meeting law. It's totally different than amending the minutes.
That's what's being requested, though.
It's actually filing an open meeting law. That's not just saying, hey, can you change the minutes?
It is.
No, it's not. It's actually filing, saying to the state attorney general that we did not follow meeting laws. That's not just change.
actually, no, that's not what we're saying. We're saying that what we do is we file our reply to the
Correct.
complainant, and the Attorney General just weighs in on, you know, whether it's appropriate or not, if the complainant says that they're not satisfied with the reply.
That's still the same thing to me.
They're not providing
yeah.
anybody with free legal advice.
This is the proper avenue to take
Yeah.
when complaints like this come forth. And all that's being asked is to amend the minutes. You look at the complaint, and there's a section on every open meeting law complaint asking what do you want the public body to do to address your complaint. And the request here is to amend the minutes.
Okay.
It's just a formal request. I don't think we need to take it personally.
I'm not taking it personally.
We
I'm
can do
taking it
better.
as the board that they're wasting 8 of them. If this didn't come last month, don't write it on the same thing as last month, people. You're just jumping on the ship.
This is for a separate meeting, though.
No, it's the same. It's all
A
the same.
separate set of minutes. This is for the
Yeah, this is for May 7th.
May 7th as opposed to the April 9th minutes.
Yeah.
It says, doesn't it say? Oh, this is from the 7:30.
Yep.
I gotcha.
Yep. Okay.
All right, we'll just do this every month, I guess.
No, it's not going to be every
That's
month.
fine.
We're going to do better. We're going to do better. We're going to get less of them. Other boards have been through this motion
We'll
many
satisfy 'em.
times.
We'll make them satisfied. Keep amending them.
We'll get better at it.
Oh, yeah,
By we, you mean
by me.
by we?
Well, we can reflect this. Like, I think there's sometimes a learning process about the level of specificity and summary that is required to satisfy the.
The people
The
is not, they're not required to be satisfied. It states.
Well, to satisfy
what you
the
have
open
to
meeting
do.
law.
It doesn't state you have to satisfy every person in
No.
the seat. And if they don't like it, they can say, I think Steve Carmen didn't say this, and I think he said this. And I mean, at some point, you could say that every meeting. I guess we'll just do it. Just
No,
keep
no,
going.
but I think you misunderstood my statement. I didn't mean to satisfy the complainant. I meant to satisfy the open meeting law,
Yep.
which is to accurately summarize the meeting for those who were not in attendance.
Okay.
Okay, we got an email from Linda Jaskowiak, whom I actually ran into here at the town hall. She and her husband had questions about the property known as the Bacon Farm, 16 Main Street. That they said that they were looking into dividing up the property a certain way, and also possibly installing a ground-mounted solar electric generation facility on the back part of it. So, and this printout that I have of the email is just the first part of that discussion. They also had questions about the street that they can use to access that back part of the property, which is called Limerick Street. It's really kind of a dirt road. And we're still not 100% sure whether it's a town road or a private road. Because believe it or not, the town doesn't have an official inventory of the streets.
Good gracious.
Yeah. And former assessor put together in his spare time kind of a informal inventory, but it includes a lot of things that he couldn't find information on too, so. Yeah, so, but in any event, we'll probably hear more from them about this as the process goes on. Then we have a notice from the Sturbridge Zoning Board of Appeals and a couple more that just came in the other day that I want to include because they're time delimited here. The notice from the ZBA says that they approved a special permit for 92 Westwood Drive to construct a 59 square foot addition to the home for a mudroom and covered entry and to replace the rear deck with a larger deck, and that was filed with their town clerk on June 18. So the period for appeal of that decision has already passed. But we also have a notice of a special permit decision from the Sturbridge Planning Board to grant a special permit for sign relief to allow the erection of an 89.57 square foot wall-mounted sign where 30 square feet is allowed under the sign bylaw. And that decision was filed with their town clerk on July 30, so there's still time left, another 13 days, to appeal that if people don't like the big sign. And then finally, we have another notice from the Town of Sturbridge Zoning Board of Appeals of a public hearing notice for a special permit for John and Emily Kingsbury to be held on Wednesday, August 20, 2025 at 6:35 p.m. at the Center Office Building, 301 Main Street in Sturbridge. The applicant is requesting a special permit to allow a 298 square foot addition to the existing house to square off the foundation as shown on the plans and supporting documentation submitted. The proposal will increase the nonconformity in regards to the side setback, with the existing setback at 17 feet and the proposed setback at 12.2 feet. No other nonconformities will be intensified as a result of the proposed alteration. The property is located at 23 Library Lane, that's in Sturbridge. So if you're interested in that, that's where to go on the 20th of August. And that is pretty much it. I'm glad that we have someone who's interested in the open planning board seat. We got that. If anybody has any suggestions for the associate member, people who might be interested in that, let me know and I'll pass it on to the select board.
We're gonna have Bruce for next meeting though, right?
No, he was done. He's done.
He's done?
He's done.
Okay, so maybe we need to talk about this. Because we won't have enough to do a special meeting.
Well, we will need to have at least 4 members available to vote, right? Now, we can try and schedule the joint meeting with the select board for that meeting, if that works. I mean, that's what we did the last year, when we had another vacancy. So, if everybody's good with that, I'll put out feelers and just see if the select board is amenable to that.
Yeah, because that, that would definitely be an issue we're gonna run into, and I don't want a last minute. I thought that's what Bruce was kind of leaning towards when he was like.
Well, we'll take that as the first item of business.
Yeah.
So we get that out of the way before we go on to the public hearing. All right. And maybe we'll also have an associate at the same time.
Yeah, maybe.
If we have it.
But at least if we put out that now, we have a month to make sure.
Yep. So I'll take care of that.
Thank you.
All right. Anything else pending? No. Okay. Motion to adjourn?
I make that motion to adjourn.
Okay, second.
I'll second.
All those in favor of adjournment, please signify by saying your name and aye.
Steve, I.
Chris, I.
Lisa, aye.
And Kevin, aye. And we are adjourned at 9:01 p.m.
Holla.
Have a good night. everybody.
Thanks, Lisa. Good night.
Have a good one.
All right.
Holly, you know Jen? Jen, the swimmer on South Pond? Jen Yorzik? Her dad was the professional Olympic. She does all the swimming. So me and Chelsea, my neighbor, swim. We have the swim this on Saturday, the mile.
Oh, you're kidding.
Yeah, so we swam tonight. I'm like, I don't know if I should. I feel so good. I swam, came out, my nose, I couldn't stop. My